copyright amendment or copyright legislation. So the first thing to note is, of course, the function of copyright law. And copyright law has various justifications for protection, but the most popular justification is, of course, the economic justification, the incentivization of creation. And that is the basis for the protection provided for in the South African Copyright Act. Now, the sources of our copyright law in South Africa, the first thing to note is that we don't have any sort of common law when it comes to our copyright. South African copyright law is heavily based on the old British copyright law. From the 1911 British Copyright Act, the 1916 Patents, Designs, Trademarks and Copyright Act was promulgated in South Africa, and that was pretty much a copy and paste of the British Imperial Act. And after that, South Africa has developed its own copyright regime. And the legislation in force at the moment is the Copyright Act 98 of 1978. And as you can see, of course, that is quite an old piece of legislation. And that is also why we are currently in quite a rigorous process of copyright reform, trying to update our copyright legislation to meet the demands of the new technological era. Furthermore, South Africa is also party to various international agreements which set certain minimum standards of protection, such as the Berne Convention and the TRIPS Agreement. Once again, this is also one of the considerations for updating our copyright legislation, as there are further international agreements, such as the WIPO Copyright Treaty and the Performers and Phonograms Protection Treaty, that South Africa still needs to enact into our laws. The important thing here is to note that copyright in South Africa is a creature of statute, meaning that if protection cannot be found within the four corners of the Copyright Act, no protection exists. All right, so for copyright to subsist, there are certain requirements that need to be met. Importantly, in terms of the Berne Convention, copyright protection is automatic. So once these requirements are met, there will be automatic protection. The first requirement is that the work in question must be an eligible work. Now, there is a set of categories of eligible works set out in the Copyright Act, and the work in question needs to fall within one of those categories to qualify for protection. Second, the work needs to be original. Now, originality for purposes of copyright law is not originality in the colloquial sense, meaning new or novel. In South Africa, we have quite a low standard of originality, and we refer to the so-called sweat of the brow test, which basically just means that the author must have expended their own and sufficient skill, judgment, and labor in the creation of the work, and the work wasn't just a slavish copy of an already existing work. The third requirement is that the work must be in a material form, and this is based on the idea-expression dichotomy, that copyright does not subsist in ideas, but only the expression of such ideas. And then the final requirement is that the author needs to be a qualified person, meaning domiciled or resident in South Africa, or the work has to be first published in South Africa. And then in terms of our international agreements, such as the Berne Convention, there is the principle of national treatment, which means that foreigners' rights will be treated equally and reciprocally to locals. All right, so as I mentioned, the first requirement for subsistence is that the work must be a so-called eligible work. And here is the list of the eligible works in the South African Copyright Act. And it's important to correctly classify a work in a specific category, because as you will see, there are different principles applicable to the different categories of works. Okay, so I'm just going to look at a couple of eligible works by way of illustration. So the first form of copyright work is a literary work. Now, literary works can be any sort of combination of letters and numbers or symbols. And once again, they must be the expression of the author's intellectual effort. And it's important to note that here we are not referring to literature. So a work can be regarded as a literary work irrespective of the literary quality of the work. And in South Africa, the definition of literary work includes tables and compilations. So databases are protected as literary works in South Africa as well. Of course, that protection is in regard to the arrangement of the data and not the data itself. The second type of work that we'll briefly look at is artistic works. As with literary works, we aren't necessarily looking at art. So this definition of artistic works is quite wide and not just limited to what may traditionally be considered art. So that's once again, irrespective of artistic quality. In the definition, it also includes what we call works of artistic craftsmanship, and those can be things like furniture, toilets. So yeah, this definition is much wider than just art proper. Another form of eligible work is what we call cinematograph films. Once again, here, this definition is much broader, so it does not just refer to movies. As you can see there, it's referred to as any fixation on film of data, signals, or a sequence of images capable when used in conjunction with a device of being seen as a moving picture. Now, interestingly, in South Africa, video games is an example of a work that is classified as a cinematograph film. The Copyright Amendment Bill proposes to change this a little bit by providing for a new type of eligible work known as audiovisual works. And as you can see from the definition, it is relatively similar to the definition of a cinematograph film and specifically includes cinematograph films as well. And the purpose of this definition is once again to come up to par with the international standards of protection as per the various international agreements to which South Africa has assented to. Another form of copyright work that we look at is computer programs. Now, computer programs, if you look at the definition, it only refers to the computer code itself. And prior to the inclusion of this definition in the South African Copyright Act, source code was protected in terms of, as a literary work rather, and this definition was then later included so that computer programs became their own eligible work. It is important to note that the way that this is defined means that computer programs, the eligible work only protects the source code, and it shouldn't be confused with software. Because once again, if we think about the idea expression dichotomy, the protection of software might mean that you end up protecting not just how the code is written, but what the code does. And that is regarded to be more of an idea than a material expression of idea. So here, the protection of computer programs is specifically focused on the actual source code, the written source code of the computer program, and not necessarily what that source code does. That is also seen in how the eligible work is defined, where it says that it directs its operations to bring about a result, meaning it might be an incorrect result, it might be an unwanted result, as long as the way that the instructions are written actually produces some sort of result. All right, so once all the requirements for subsistence are met, like I say, copyright subsists automatically. Now, generally, the rule of ownership of copyright is that the author will be the owner. In South Africa, an author is a technical term, and author is defined in terms of the type of work in question. So for example, the author of a literary or artistic work is defined as the maker or creator of the work, whereas the author of a photograph is defined as the person responsible for the composition of the photograph. So this might not necessarily be the person that actually presses the button to take the image. The author of a cinematograph film, a sound recording, or a computer-generated work is defined as the person who made the arrangements for the creation of the work. And this, once again, may not necessarily be the person that actually made the recording or the cinematograph film. And these arrangements generally refer to financial arrangements for the creation of a work. And then finally, the author of a computer program is defined as the person who exercised control over the creation of the work. Once again, this will be a factual inquiry depending on the facts surrounding the creation of the work, and it might be the case that the person that actually did the coding wasn't the person that was in control of the creation of the work. So while the general rule is that the author is the owner of the copyright in a work, our Copyright Act also provides for certain exceptions to this rule. The first exception is the situation where an author under a contract of service creates the work in the course of their employment. In terms of the exception, the employer will then be the copyright owner in that work. The second exception is where a person has commissioned the creation of a work, and the Copyright Act provides for specific types of works where this exception will apply, namely photographs, portraits, gravures, cinematograph films, and sound recordings. So all of these works, where they have been commissioned, the commissioner will be the copyright owner of that work. If it is a work falling outside of these categories, so for example, a literary work, the commissioner exception will not apply. And then finally, there is also exception for where the work has been created under the direction or control of the state. In that case, the state will be the copyright owner of the work. All right, so once copyright ownership has been determined, copyright grants certain limited exclusive rights in the work in question. And this grants the copyright owner the ability to exercise or authorize certain restricted acts in relation to the protected copyright work. Now here on the slide are some of the general restricted acts that apply in relation to copyright works. Once again, different principles apply to different types of works. And so the restricted acts may differ depending on the work in question. So there you'll see reproduction, publication of an unpublished work, performance in public, broadcasting or transmission, adaptation. And then the Copyright Amendment Bill proposes to add further restricted acts, the so-called communication to the public right and the making available right. And these are, once again, technology neutral rights that aim to cover current and new forms of communication made possible through developments in technology, such as interactive communications as well. Once again, this is, of course, these amendments are included in order to bring South African copyright law up to par with the international standards of minimum protection. All right, so in terms of royalty rights, in South Africa, currently, there are no specific provisions related to equitable remuneration or anything of that sort, save for Section 9A, which relates to sound recordings. And this is the so-called needle time royalty rights clause, in terms of which the copyright owner in a sound recording is entitled to a royalty each time the sound recording is played for commercial purposes. The Copyright Amendment Bill proposes to add quite a few extra royalty rights in our legislation. The first is Section 6A, 7A, and 8A. And these sections provide for the fair share of royalty for the author of the copyright work from the royalties received for the execution of any of the restricted acts. And this royalty right is notwithstanding any assignment of the copyright or any authorization by the copyright owner for the execution of such restricted acts. And these royalty rights need to be determined by written agreement. And the proposed sections also provide for certain exceptions where this royalty right will not apply, such as where the author is the owner, of course, and where the work is created in the course of employment or under the direction of the state. And then Section 7B refers to the resale royalty right in relation to visual artistic works. And this is basically a royalty due to the author of an artistic work each time there has been a commercial resale of the physical work. And this right will last up to 50 years after the death of the author. And it is inalienable except through testamentary disposition or operation of law. Now here, once again, it's very clear that these amendments, the purpose of these amendments are to, once again, bring up South Africa's copyright protection up to standard of the international standards for minimum protection, having some form of royalty right for authors, as well as the resale royalty right. In addition to economic rights, our Copyright Act also provides for the moral rights of the author. Now, these rights are irrespective of the copyright ownership in the work, and they are inalienable sort of personality type rights. And because of that, they also cease upon the death of the author. In South Africa, we have two moral rights. The first is the right of paternity, which is basically the right to claim authorship of a work, or the right to be recognized or credited as the author of a work in instances where you have not been credited or where someone else has been incorrectly credited. And then the second right is the right of integrity, which is the author's right to object to any modification, mutilation, distortion of their work, where such modification will be prejudicial to the author's honor or reputation. So it's important to note that modification to your work is not objectionable per se, but if one can show that such modifications will be prejudicial to the honor or reputation of the author, the right of integrity may be applied. All right. So considering all of these economic rights that I've briefly discussed now, our Copyright Act provides that such rights last for literary, music, and artistic works. They last until 50 years from the death of the author. And once those rights then expire, the work falls into the public domain, meaning it can be used without any restrictions, without having to obtain any authorization or license or consent in any form. And then the term for films, computer programs, and sound recordings is 50 years from the year in which the work was first published or lawfully made available to the public. So generally, term of copyright is life of the author plus 50 years, or for those specific types of works, just the 50 years from publication. All right, so copyright infringement is provided for in our Act. And of course, this is where a third party does any of the restricted acts which are exclusive to the copyright owner without the consent of that copyright owner. In terms of our act, the copyright owner, as well as an exclusive licensee with notice to the owner, may bring copyright infringement proceedings. It's important to note here that if the author is no longer the owner, they cannot, or not the owner or an exclusive licensee, they cannot bring infringement proceedings. Okay, so there are various forms of copyright infringement, generally primary infringement, secondary infringement, or criminal infringement. So primary infringement would be where a third party is performing any of the restricted acts without the consent or authorization of the copyright owner. With primary infringement, it's strict liability, meaning that there is no knowledge requirement, and ignorance of the law is not a defense. So you don't need to know that what you are doing is infringing to still be found liable of primary infringement. And of course, the most prevalent form of primary infringement would be reproduction. And when we consider reproduction as a form of copyright infringement, there are various considerations to take into account. First being that there must be sufficient objective similarity between the copyright work and the alleged infringing work. And secondly, there must be some form of causal connection between the two. So we also have what we call indirect copying, where you make a copy of a copy. And at the end of the day, that still means that you have made a copy of the original work. And that may still be regarded as a infringing reproduction. At the end of the day, there needs to be some form of copying. Once again, here you can see that the restricted acts need to be precisely defined in order to decide whether there has been a restricted act performed by a third party and whether such act is infringing. The second consideration when we look at primary infringement is that the restricted act needs to have taken place in relation to a substantial part of the work. So that means that the infringement does not have to be in relation to the entire copyright work, but it may just be a little bit, a substantial part, and determining whether a part of the copyright work is substantial in nature will be a qualitative assessment, depending on the facts of the matter. The second type of copyright infringement is so-called secondary infringement. And basically, this is where you are dealing in infringing copies of a copyright work. So it may be that you weren't the person that actually made the infringing copy, that's primary infringement. But if you are somehow dealing in or trading with such infringing copies, you will still be liable for secondary copyright infringement. And dealing may mean anything from importing infringing copies, selling, letting, or distributing such infringing copies. Now, important for secondary infringement, there is a knowledge requirement. So the alleged infringer needs to know that they are dealing in infringing copies. And there are various tests to determine whether that knowledge exists. Okay, then finally, we have criminal infringement. The acts specified in the copyright legislation are pretty much the same as the forms of secondary infringement. Here, once again, there is guilty knowledge required on the part of the alleged infringer. And a case of criminal infringement is dealt with in the exact same manner as any other form of criminal case in South Africa. And then for criminal infringement specifically, the Act prescribes certain sanctions that can be applied. So first conviction or repeat conviction, there's either a fine or imprisonment. Okay, then the amendment bill proposes to include provisions related to the circumvention of technological protection measures, as well as the removal or modification of copyright management information. Now, at the moment, Technological protection measures are dealt with in terms of the South African Electronic Communications and Transactions Act. And this act applies generally to all communications, so it's not specific to cases of copyright infringement per se. So including these provisions related to technological protection measures and copyright management information in our copyright law legislation means that it applies more specifically to cases of copyright infringement. And these proposed amendments also are cognizant of exceptions to copyright infringement where, for example, the circumvention of technological protection measures may be permitted if it was to perform an act that is exempt in terms of copyright exemptions. But we'll get to that in a second. In the event that you are found liable for circumventing technological protection measures or removal or modification of copyright management information, you will also be criminally liable as set out in the Electronic Communications and Transactions Act. All right, so if a case of copyright infringement has been made, there are certain remedies for such infringement. Section 24 generally sets out the relief that is available in a case of copyright infringement. The first is an interdict, which basically will restrain a party from doing or continuing to do the infringing activity. The second is an award of damages. It's important to note that with damages, there needs to be some sort of quantifiable loss, and there needs to be requisite knowledge on the part of the infringer. Now, generally, proving a quantifiable loss and knowledge on the part of the infringer may be a bit difficult. So in lieu of damages, there is also the option of a reasonable royalty. And here the court will have to postulate a reasonable royalty rate for the infringing activity. There's also the option of delivery up of any infringing copies to be destroyed. And finally, of course, the criminal sanctions, which I've already spoken about. Now, as I've mentioned, there are various exemptions to infringement. So this is basically defenses that an alleged infringer may use, acts that are specified in the Copyright Act that will be exempt from infringement liability. Of course, there are general defenses such as the copyright owner has not discharged the burden of proof. That could be related to their ownership of the rights, whether the work is original, whether the work is protected at all. But then, like I say, there are these specific instances provided for in the Act as well. Now, the first is the fair dealing exemption. And these are specific circumstances set out in the Act where one may perform a restricted act without the consent or authorization of the copyright owner. The first is for research or private study or personal or private use. Second is for criticism or review of the work in question or of another work. And the third is the reporting of current events. Now, with criticism or review and reporting current events, it's important that the source is indicated in the work in question. There are various policy considerations for these fair dealing exemptions related to the economic arguments for limiting the monopoly over copyright works, freedom of expression, and the public's need for information. And then, of course, there are other exemptions provided for in the Act, such as use in judicial proceedings, quotation from publicly available literary works, use in illustration for teaching, and reproduction for purposes of broadcasting. We also have an exemption for reverse engineering of 3D artistic works. So it is permissible to reverse engineer a 3D product derived from a 2D artistic work to make your own design drawings from your observations from taking the 3D product apart. and your 2D design drawings will not be regarded as an infringement of the original design drawings, although they might be very similar. Then finally, our Act provides that regulations may be promulgated from time to time that also have specific exemptions for reproduction. And in terms of in accordance with the Berne Convention 3-step test, these exemptions may not be in conflict with the normal exploitation of a work and must not be unreasonably prejudicial to the interests of the copyright owner. So we have certain of those regulations specifically related to making reproductions for classroom use in an educational environment, and reproductions made by libraries and archives. Now, the Copyright Amendment Bill proposes quite extensive changes to the exemptions to infringement. The first and perhaps most contentious proposed amendment is the inclusion of so-called fair use, which is the US approach to copyright exceptions. This is where there is way more flexibility, and there are certain factors that need to be considered to determine whether certain activity is exempted. And those factors are the nature of the work, the amount and substantiality of the work that has been affected or used, the purpose and the character of the use, considering whether it is for a non-profit purpose, for example, and then the substitution effect on the potential market for the work in question. Furthermore, the proposed amendments propose to include temporary reproduction and adaptation, where such reproduction and adaptation is integral in an essential or a technical process. So, for example, caching a website. The third proposed amendment is reproduction for educational and academic activities. This would be reproduction for things like study packs or resource lists in the educational environment. Once again here, it's important to note that such reproduction should not be for educational or rather commercial purposes. There is also a proposed amendment to include an interoperability exemption for computer programs. So this is where a reproduction of a part of a computer program is indispensable to achieve interoperability between different computer programs. It's important to note that the person making the reproduction must have a legal right to use the copy which they are reproducing from. And then there is also a proposed general exceptions for libraries, archives, museums, and galleries. And these exceptions generally relate to making reproductions for archiving or preservation purposes, format shifting to convert from aging technologies, acquiring and importing works legally made available in another country, and providing access to digital versions of copyright works. And then the final general proposed exception would be for persons with disability. And these exemptions relate to making accessible format copies for persons with disabilities and being able to do so without the authorization of the copyright owner. Once again, these activities must be for a not-for-profit purpose. And of course, the source of the original work needs to be indicated on the accessible format copy. All right, then finally, copyright is classified as movable property, which may be transferred, and such transfer can be effected by way of assignment, testamentary disposition, or by operation of law. Now, copyright is considered to be a bundle of rights, and the copyright owner can decide how they want to chop and change, which rights they want to assign. They can assign only certain rights for use in certain geographical areas or for a certain duration. And such assignment needs to be in writing and signed by the parties in question. And if an assignment is affected, of course, the ownership in the rights are passed to the assignee, and the assignor basically becomes just like any other third party in relation to that work. The Copyright Amendment Bill proposes to include a 25-year revisionary right for literary and artistic works, which would mean that an assignment of the copyright in a literary or artistic work may not be for a duration longer than 25 years. Licensing is another way in which a copyright owner may permit a third party to use their copyright works or perform any of the restricted acts in relation to their copyright works. Of course, with a license, it's just permission, so there are no rights being transferred per se. And there are various forms of licenses. So you have an exclusive license, and this will be to the exclusion of the owner of the copyright as well as all third parties. An exclusive license needs to be in writing and signed. Then you also have a sole license, which is to the exclusion of third parties, but not the copyright owner, or a non-exclusive license, which is, as is stated in the name, not exclusive. So a copyright owner may grant various non-exclusive licenses in the same rights to multiple parties at the same time. As I've mentioned with assignment, because copyright is a bundle of rights, the copyright owner can decide which rights they want to license and the circumstances around that as well. Finally, the Copyright Amendment Bill proposes to include a whole section on collecting societies into our copyright legislation. So at the moment, we have regulations governing collecting societies in South Africa, but only related to collecting societies administering the needle time royalty rights and sound recordings. So by including the provisions on collecting societies in the copyright legislation, those regulations would then apply to collecting societies across the board, administering all copyright rights and not just needle time royalty rights. Okay, and that is all from me. I hope this has been an insightful and brief rundown of the South African copyright law. And my information is on the screen if you have any questions. Goodbye.